with High Tech Answers, and thank you for joining us as we head into a long holiday weekend of Memorial. Happy Friday to all of you, and we're glad to be back again this month. HIPAA Chat, of course, is sponsored by eFax Corporate, which is a brand of J2 Cloud Services. Founded in 1995, J2 is an award-winning leading provider of Internet services through its two divisions, its Business Cloud Services and its Digital Media. Please visit them online. They have several products that help with secure encryption of health information and through faxing and mobile and other devices. And we are proud to have them as our sponsor. Without them, we couldn't have HIPAA Chat each week. Before we begin and I introduce our favorite host, Steve, and our special guest, Matt, HIPAA Chat is now on LinkedIn.
Yay!
You can look at the link below. You can click on it. Please join the discussion. We're going to be sort of taking the multitude of questions that we get from our monthly HIPAA Chat and digesting them further in LinkedIn. So
yeah,
check out.
I mean, we have questions that we in almost every month that we just don't get to, and you know, I know we've said, and the plan is that we will answer those questions on the group, so that not only the people ask it will benefit, but everybody will get the benefit of those answers, and I'm excited. I think it's going to be a great supplement to.
Yeah. We're excited. The chat on YouTube, you can find it on YouTube if you search for HIPAA Chat or High Tech Answers, and on our internet radio station, healthcarenotradio.com. You can go there and you can download actually all the podcasts of HIPAA Chat if you'd like to, listen to them while you're running or working out or.
What? You mean I'm on iTunes? Does that mean I'm on iTunes? I didn't know. I'm like, Netflix is going to be calling me soon, I'm sure.
I know.
My own show, yeah. So
Steve, speaking of your famous face, before we begin, I have to tell you in the audience, I was in Lake Como last week, and for 5 beautiful days.
Everybody, that's Italy.
Lake Como, Italy, where actually George Clooney spends the summer. I am now 1 degree separated from George Clooney. We had one of his drivers take us around Lake Como. How about them apples?
Real? So are you like friends with him on Facebook yet?
No, but I'm 1 degree away. I'm working on it.
You're close. Okay, you're working.
Steve Spearman, of course, we think he looks exactly like George Clooney, only he does not have a $30 million villa on Lake Como. On Lake Como is the founder and chief security consultant for Health Security Solutions. He has been in the space for decades and is really well known, obviously, in the industry. Please check out his own monthly webinars at healthsecuritysolutions.eventbrite.com.
Let me do my plug. So we do have webinars we do them once a month, and the HIPAA 101 and Compliance Essentials is scheduled for next Friday. So, as always, that we cover a lot of great basic information on that. They're free, of course. So we hope you'll join us there. So. Yeah,
and then of course contact Steve from his email. We're very pleased to have with us Matt Fisher today. Matt is an associate with Merrick O'Connell, and he chairs the firm's Health Law Group. He actually is a regular contributor to our High Tech Answers blog and as well as our HIE Answers website, and is a really well-known face and voice in the space of security and privacy and HIPAA in general. And we're glad to have him on board talking about privacy rules today. You can contact
Ryan Reynolds.
Ryan Reynolds, that's who we think. That's your LA avatar, Ryan Reynolds. I like it.
I'll run that by my wife.
She'll be thrilled. So yeah.
Just don't star in the Green Lantern or whatever, the green something.
No. Yeah. We could go either way on that. So,
It wasn't a good movie. Yeah.
No, it was not. It's not.
No.
Was that Ryan Reynolds? That wasn't Ryan Reynolds, was it? Oh well. Anyway, go on.
It's some superhero green thing or whatever. Anyway, contact him at mfisher@merrickoconnell.com. And I know he will get back in touch with you. Before we actually go into our audience questions that we received through your registration, we appreciate it. We'll address those questions and obviously take questions live from our attendees today. Just a couple of, and some of the guys turn it over to you, and then we'll dive right into the Q&A.
and I'm actually gonna go against form, but I'm gonna let Matt take this on. But before we hop in there, I have I'm gonna request something of the listeners. I am currently writing an article, maybe a series of articles, on a topic where I would love it if you would reach out to me so I can possibly interview. If you're the CIO of a hospital, it's going to be it's going to be an article or articles on medical devices and cybersecurity. I think it's an area that's underreported and that there are some concerns, and I want to be able to write some things. So if that's an area that that your job is impacted by that, or you have something interesting to say, please email me, because I'd love to talk to you about that. So, and then I'm going to hand this over to Matt. Matt, take it away.
Yeah, well, no, thank you. And again, thanks for inviting me. This will be, this is the serious part that I'll give. But, as I said, I'm an attorney, but,
But you're interesting.
Yeah.
You're interesting, so that's the exception. Okay.
Yeah, but I just need to say, the statements today are not going to be legal advice, but are, my views on things. And if you have any specific questions, you can certainly feel free to reach out to me, and we can explore things that way. But to give a little bit of an overview of the HIPAA privacy rule, it's probably one of the longest lasting pieces of HIPAA at this point. And really, if you're thinking about the privacy rule, is really designed to protect against the uses and disclosures of protected health information. So you're really looking at trying to limit when PHI can be used and in what instances it can be used. So the big pieces of the privacy rule are you divide it into the authorized uses and disclosures. Just do it as right without needing to seek any type of an authorization. Whether the individual who the information relates to has to specifically give authorization to it, or if they just need to have the opportunity to object to the proposed use or disclosure. So it's really, at least in my view, within the HIPAA realm, a kind of a fairly black and white aspect to it. If you go to the privacy rule, it actually will give you a lot of detail in terms of what you can and can't do, and what you need, what policies and procedures you need to put into place. So it's really, the two major aspects of HIPAA, privacy and security. The privacy is pretty much designed to be a one-size-fits-all, for better or for worse.
Yeah, in fact, there are no, we talk a lot on the program about addressable versus required safeguards. There are no addressable safeguards under the privacy rules. I believe, isn't that correct? That
yeah,
that's an example.
And that's a great point. Because it's organizations put their privacy rules into place, and they'll be like, but we don't do this, especially with, amendment or access. They're not, especially a lot of business associates aren't necessarily maintaining designated record sets, but you still have to have the policy in place just in case something could change in the future. Just because they want all that in place, and, especially from the business associate side, you're signing a business associate agreement and you're agreeing to those provisions, whether or not they're directly applicable to you or not. So it's, I agree with you. There is that big difference from the security rule where, instead of having under security required and addressable, you've got things that are just required. There's not so much of the addressable aspect to it. So that's actually a nice kind of transition to go into what are some of the differences. Again, privacy is looking to determine how the information can be used and controlled. Individuals can have some ability to impose some limits on it, and then also the organizations using it are going to need to provide information to the impacted individuals in terms of how they're going to go about using it. Security rule is really going to, I always hate to say this, but it's talking about the security of the protected health information. I think security is a perfect rule for it, or perfect word for it. There's kind of not a better one to substitute there. But then you're looking, as the slide says, looking at both all administrative, physical, and technical safeguards. And while for the most part you're wanting to think about the security of electronic protected health information as physical aspect to it should flag for you. You can't forget about the paper and the actual devices where things are stored. It's not just the information when it's being sent around. Pretty decent, quick overview of the privacy and security rules. Steve, I'll let you fill in any additional details if you want, but I always like to get into the specifics by using examples, and I think we've got a lot of good questions.
Oh yeah, we do. And I mean, I mean, when I'm talking about this, I say that if we're talking about non-digital information, like a doctor talking loudly in the waiting room of a hospital within earshot of other people in detail about a patient, because we're not talking about digital information, it falls squarely under the rubric of privacy. Whereas, once that same conversation is recorded into a digital thing and then put into a chart somewhere, it's then covered under sort of security and privacy. That's kind of how I've summarized it. I don't know if you have talked about it that way, but.
Yeah, no, I think that makes sense. I agree with you. It's when you're talking about stuff out loud, I definitely agree with you. You need to have the privacy rule in mind. It's you're certainly not prevented. I know you're not suggesting it, that you're not prevented from talking about it, but just be aware of the surroundings that you're in when you're doing it, and to the extent you can, try and limit or prevent others who shouldn't be hearing what you're talking about from hearing it.
Yeah.
Right.
Yeah.
Well, are you gentlemen, you ready to dive right in?
Let's do it.
All righty. Again, we'll go through the questions from some of the registrants that were topical to privacy rule, and then we'll take some questions from the live attendees. Okay, so first and foremost, please discuss the regulatory guidance for disclosing information to caregivers.
Yeah, so when you're talking about giving information to caregivers, this is one of those things that's squarely under the privacy rule. And it's one of those aspects where it's because under the privacy rule, PHI can be shared with family members or caregivers, and you shouldn't just be freely sending it out, but you should probably be taking some reasonable steps to figure out who's involved in that person's care. But then if you are sure that someone's involved in it, or if even someone's paying for someone's care, then you can start giving out some of the protected health information. So it's one of those things where I think in the privacy rule there is some recognition of the fact that people don't go into healthcare by themselves, and that they have family members or others that they rely upon to help them kind of navigate the system.
Right.
So even though the privacy rule does say that, if the individual whose information is going to be shared has specifically said to their provider or to someone else, you cannot share information with a particular person, then no matter, even if that person is a caregiver, then you're not going to be able to share the information with them.
Yeah. What's interesting to me about this, Matt, is that there are cases where a misunderstanding of this issue actually kind of led to a certain type of, to me, tragedy. I don't know if you heard about the case at a hospice house. I think it was in Ohio or wherever, where because of the policy of the hospice required in order for a family member to be with a patient, they had to have written authorization. So when the patient was literally expiring within the last few hours of his house, and there were all these family members that were outside in the waiting room that, because they weren't on some list, were not allowed in to be with their beloved, and clearly a misunderstanding of. So it's kind of, time and place issues like that. I mean, let's use common sense, folks.
Yeah, and also, that example you just gave based on how you described it, it doesn't sound like information is being disclosed. That sounds like they're denying people the ability to visit a family member. So it's, as we all know, you go into a hospital and you can visit, you visit your friends, you can visit your family members, and there's no problem with it. If they're going to be providing some care, then maybe, if you're not sure who's involved in the care, ask them to step outside while you discuss particular issues. But I agree with you. Denying a visit like that definitely sounds like a misunderstanding or the rules being misconstrued.
Well, but wouldn't you say, let's say that you've got a person who's, just now gotten some significant, lab result back, and there are 5 family members in the room. In that context, sort of time and place, if the doctor's saying, well, let me tell you what the lab results found, you wouldn't need to tell the patients to get out of the room. I mean, the family members to get out of the room. In other words, it's not just visitation. They have an interest in the care of their, loved one, and the rules would not, unless the patient had explicitly said, I don't want you to ever talk about my clinical condition with any family member except my wife, you wouldn't have to ask them to leave under those conditions, right? I mean, they're...
Yeah, I mean, you wouldn't necessarily have to ask them to leave, but, probably a good idea in that case would be, before the provider goes out and just says what the results or whatever the issue is, you can ask nicely, do you ask the patient, do you mind if I talk about these issues with your family members present?
Yeah, that's
or would you prefer otherwise? Because again, as I said, even though you can talk about it with the caregivers, it is one of those things where the person has to have the opportunity to object to that disclosure. So I think, do you mind, or something similar along those lines, I think that'll offer the protections, because then if they don't object, then you've really satisfied your requirements.
Yeah.
Sort of a similar kind of question relating to continuity of care. Disclosure records that are in your chart but are not yours. So, an issue where some of the information required is being sent to another physician for continuity of care, but not all of it is their information.
So I'm going to let Matt answer, but let's say you're a primary care doctor that has done some done blood draws, and then then you refer that patient to, let's say, a specialist, and you send those the results of those specialists. I think they're kind of asking, well, are there any limitations on whether that specialist could disclose those labs, given that they weren't the one that did it? I think that's what the question is asking. Does that sound like a pretty good interpretation of the question?
Yeah, I think it is a CCA, so it is related to continuity of care, and I think what the asker is saying is the information, the entire patient record was sent over to the referring provider. But not all of that information is theirs to use, or should be theirs to use, I guess.
Yeah, so, I think there's a couple pieces to kind of tease out of the question there. The first question being, as Steve gave in the example of, can a primary care provider send results over to the specialist? Clearly, for treatment purposes, so the patient is referred over there from the primary care to the specialist, and that, care needs to be provided. So yeah, the rules are very clear. For treatment purposes, the information can be shared very freely, and there's no authorization or need to be able to object required. That's, the privacy rules are very broad in terms of what disclosures and uses can be made for treatment purposes. But as I said, kind of to tease it out a little bit more, I think it was you, Carol, that suggested maybe the entire record was sent over instead of just the information that the consulting physician needed. One aspect of the privacy rule when you're thinking about any use or disclosure is you need to remember that any disclosure should really just be the minimum necessary amount disclosed. So you shouldn't just be sending the whole hog. You should send just a piece of it. So you want to think about what information is necessary in this example for the purposes of the consult. If it's, if you're only talking about one particular issue that that particular patient is facing, maybe they don't need the entire history, or they don't need to know about previous, a completely unrelated surgery. So I think that's where you probably need to pay attention to it is the minimum necessary being provided? And then, kind of the last piece of whether or not the consulting or the physician or the specialist can be the one who discloses or talks about, results to the patient. I don't think I would see any problem with that if it's all part of it. If it's results that are part of and connected to the care that the specialist is providing, then, I think as the patient, you expect to hear everything from, the physician or the other provider that you're in front of.
Right.
Hey, Matt, this is, just sort of occurred to me. I'd like to ask you your response. What about clinics, physicians, providers responding to subpoenas? One of the things that that I bet you might have read about was the case, I think, in either Connecticut or Massachusetts about a woman who had a pregnancy test, and then the father wanted the results of the pregnancy test to prove that, that the person was pregnant and wanted to claim paternity, and so he hired an attorney who subpoenaed the practice, who then released the information under the subpoena. And what are the limits of a subpoena power, and how does that affect with what you should do from a release of information standpoint?
Yeah, no, that's a great question, and it's one that it's actually a particular issue that I've had, not the exact example that you gave, thankfully, but the question, and what should you provide in response? I've certainly talked about that with a number of different clients, and so under the privacy rule, again, going back to the types of uses or disclosures that can be made without the opportunity to object or even needing a specific authorization, subpoenas and responding to court orders clearly fall within the category of things that covered entities and business associates can do. That being said, there are requirements and specifications about what process needs to occur with the subpoena. Kind of generally, and talking in broad brushstrokes, just getting a subpoena from the attorney to one of the parties in a proceeding is probably by itself not enough to give the healthcare entity receiving it the ability to disclose the information. If you've got just a subpoena, you generally need to have some reasonable evidence that the party about whom the information relates has had a reasonable chance to object to the subpoena and has not objected to it. Or a safer route is, and this is one that I know some of the people in my office will go through, because we have people who are involved in like medical malpractice defense cases where you need to get records. You just petition the court and ask for the court to issue the subpoena, because once the court issues the subpoena, now it's an official court order that needs to be responded to. And also, if you've made a motion before the court to obtain the subpoena, then the other party has definitely had the chance to object, because the court's going to give, most courts in most circumstances are not just going to issue it without the other party present.
Okay.
So, it really is, ask for some of the circumstances behind it. And, just one other thought on it, even when a court issues something, or a federal or a government agency, the scope of what's being requested. For example, I was talking with the privacy officer from one of my clients earlier this week, and she got a subpoena from a government agency asking for a particular patient's entire medical record. And I said, okay, well, it came from, it was issued by an administrative law judge, so yeah, you're going to need to respond to it. But, I said, is it really necessary that they need the whole record? Especially if it's coming from like a government agency like that, take a practical approach to it and just reach out and give them a call, especially if you're not involved in the case. If you're just a treating provider and it's, some other type of dispute, just reach out and ask, what are you really looking for? And that way you can protect yourself by, again, always, as I said with the last question, you always want to come back to what's the minimum necessary that needs to be disclosed.
Is where you said we're in that, where you had a patient needs a right to object, or where the person about whom the request is for, about their information, they need a given that the form is a subpoena, does that objection have to occur in the courts, or could it be like the practice maybe would call a patient up and say, hey, we've gotten a subpoena, are you okay if we send this on? And is that enough, or would it need to be kind of its own legal document, tit for tat kind of thing?
Yeah, so my suggestion generally is that if you're an outside party getting the subpoena, it is not your obligation to make sure that the party about whom the information relates to is given the opportunity to object. You should ask if it's occurred and get some comfort on that front. But I would probably typically not advise a client to be reaching out to for example, a defendant to say, hey, have you heard about this? Were you given the chance to object to this? Because one, I don't think the regulations suggest that you need to get involved to that degree. It just says that, if I'm recalling off the top of my head correctly, I think it just says that you need to be reasonably certain that that opportunity has occurred. And also, I would not want a client to stick their neck into it, because once you stick your neck into something, then you can end up on the chopping block too.
Yeah.
Good point. Yeah. If an EP sends and or receives PHI from one EHR to another, do they need to be registered with a HISP to be HIPAA compliant? It's a big question right now with health information exchange, of course.
This is a little okay. So a HISP is a health information
It's like
health information security provider, but it's relate like a
like
HISP
your ISP.
But it's health information, and it's related to, I know, at least to the direct messaging protocol, but maybe some others as well, where you're set up as a HISP, and that allows you to securely send and receive information. But I believe the answer to the question, the rules don't say that the transmission of data needs to be done in a manner that's secure, but I don't think it requires that it can only occur, for example, through a direct messaging protocol. Transferring data, you might be printing out a document, putting it in the mail, and sending it to them, and that's transfer of data, and that's clearly allowed. So, Matt, do you have some thoughts on this? Is this?
Yeah, no, I agree with what you were just kind of laying out there. It's this goes back to the point you made earlier about the fact that because I think this is more under a security rule, or it's a hybrid of security and privacy. From the security perspective, I agree with you. Your obligation is to make sure that the transmission is secure, and it's kind of up to you to figure out how you want to do that. From the first question, maybe the first point of can the disclosure occur at all, either a treatment, payment, or a healthcare operation purpose, those are the three huge categories for entities to be able to send around information just without needing to seek any approval or authorization to it. So I definitely agree with you. It's, think about how you're sending it, but there's no hard and fast requirement on how you go about doing it.
Yeah. Right. I mean, if an organization has set up a secure email messaging methodology, for example, where those packets are encrypted and then decrypted on the other end, I mean that's enough right there in all likelihood to basically meet the secure transmission requirement. So. There are other reasons that the HISP and the direct messaging protocol have had a lot of play related to both your ability to integrate those in with electronic health records, create auditing protocols, having that data embedded into a medical record. All those are all part of the movement, but it doesn't suggest it's the only.
Right. Must a provider disclose upfront to patients details of a BA associate who processes registration information?
What do you think they mean by registration information?
Well, maybe you have a third-party vendor who is maybe a portal or registration.
Yeah, I was thinking it was like maybe something they use a third party to help with online pre-registration or something like that.
Yeah. Okay. Yeah. Like for you know, maybe for the making sure they've signed the notice of privacy practices and gathered the insurance information. Yeah, and there's some vendors in that area. Yeah.
Yeah, although for the notice of privacy practices, I'd question if there would be a good idea to delegate that to someone else to give out your NPP. You know, because obviously, you know, covered entities are the ones with the obligations to give it out. So I'd just be, you know, sorry to have picked out that one, what you just said, Steve, but I'd probably be careful on that front.
And so I'll kind of clarify, like, so there are vendors out there that generally work on the local network, and I'm not aware that they are doing much in the internet, but where you give the patient a tablet, and in that tablet they enter in information. They can, they put this information in. It actually will come up with a form that says, here's our notice of privacy practice, and they go through it, and then they check that they've read, an acknowledgement that they've read it. And that's sort of what I was thinking. And so, okay. I think so.
I think that probably sounds okay. But you just want to, as the covered entity, you probably also want to make sure that you just have it available if someone asks, and have it posted on your website and all that.
Yeah. But I think the answer to the go ahead, Matt.
Sorry, go ahead.
Well, I was going to say no. Yeah, I mean, covered entities they don't have an obligation to reveal who their business associates are, at least not that I'm aware of. They would have an obligation under, so one of the privacy obviously provisions is the auditing of disclosures. So if a patient wanted to ask for an audit of disclosures that involve a disclosure of business associates that had, then under those circumstances I would see you would need to reveal it, but I don't know that you'd need to do that up front. I can't think of a reason.
And I agree with you. It's I'm not aware of most circumstances, or really any circumstances, where the covered entity is saying, here are all the business associates we work with, and who's getting what information. It's just kind of of how things operate. You're going to deal with some of the people affiliated with it, with your covered entity, and I think, Steve, as you said, if the information is something that you can, part of this set of data that you can ask for an accounting and disclosures about, then you'll find out about it. But other than that, I don't see, or I haven't experienced any time where you just be told up front, hey, here's a third-party company we're using for the registration. They're gonna be collecting this information from you, and they're our business associate. You just send people over and say, hey, you need to pre-register here before you come in.
Yeah. Hey, by the way, do you want to maybe talk a little bit about the accounting disclosures requirement?
You mean the morass that's the accounting of disclosures requirement?
I stuck it in. It's going to have to stay there until we, work it out a little bit. So, yeah. And you have 15 seconds, Matt.
15 seconds.
So my 15 seconds is they're trying to revise it. They got so many comments back on it that they haven't done it. Potentially getting a new proposed rule this year. But kind of in seriousness, the accounting disclosures, you can be able to ask for what uses and disclosures have been made of your protected health information. Practically speaking, I don't know how much, in my opinion, I don't know how much value that is to me. If I'm finding out, why, I guess from my perspective, and this is a personal view, is like, if I ask for that, what am I going to do with it once I find out about it? The only potential thing I could see is if you feel like you're getting some inappropriate communications, you ask for it, and to make, maybe as some type of verification to see if, the entity with your data is doing something funny. But just to randomly call up and say, hey, I want to know everyone that you've sent the information to,
Yeah, I mean, if you're involved in a lawsuit, then discovery is going to give you a lot of ability to see what's happened. And then, of course, I've run into lots of circumstances where I'm sure you have too, where a patient registers a complaint and say, hey, I had my neighbor or my person from church that mentioned that she'd seen me and saw that the blah, blah, blah was going on, and then you'd have to have an ability to audit the chart and say, based on our audit, we confirm that there was inappropriate access, blah, 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 we took these actions. But yeah, this just sort of carte blanche, what kind of regulation, it seems like it could turn into a fishing expedition, and it's it's a difficult thing.
Yeah, and with the example you just gave too of a patient calls and says, hey, I heard that I was at church or I was out in the community and someone I know who works at the hospital was talking about something. I've seen that scenario pop for an accounting for disclosures. They're usually a complaint.
Right.
And then, I definitely agree with you. The organization has to have some ability to go back and investigate and audit it. But, again, I haven't personally seen it come up in a formal accounting for disclosures request. So again, it's been one of those pieces of the privacy rule that I just question the practical aspect to it, and especially as you said, if people are doing a fishing expedition, that can become very burdensome because there's pretty precise requirements in terms of what needs to go into that accounting report.
Right.
And that was the big problem with the proposed rule from a few years ago. They tried to expand it so much that everyone cried foul and said this is going to swamp us because it's just a ridiculous amount of information that would be included.
Is there any requirement to extend privacy rules to a VA or other chain of trust organizations? Sort of similar to what you
well, not fully though. I mean, the easy answer is yes, but there are certain privacy obligations that a business associate does not have to fulfill unless they are fulfilling the privacy obligations of a covered entity under a contract. So, for example, they don't typically have to have a privacy officer, in place, but there are certain obligations contained in the wording of a business associates agreement, such as accounting of disclosures that any business that's really privacy. We're talking about privacy. So that essentially bound them to certain elements of the privacy rule. That's kind of how. So as usual, you say yes, I complicate things. Which is kind of the way I roll. But
I
you
agree.
That's okay.
Yeah, no, I agree with you. It is a more nuanced answer than just simply yes. But especially after passage 13, there's such a slim line between a business associate and a covered entity now. There's I just from good practice, I think a business associate should have just about the full complement of everything in place. Because even if they don't have a particular the privacy officer saying a piece of it, even if they don't specifically have to have it in place, why wouldn't you?
They're on the hook too. They may be on the hook.
I'm not, you know what, Matt? I'm not sure that I agree with that. I mean, I'd say it's clear they don't have to have a privacy officer. That's what is also clear, though, is that many of the obligations that we've been talking about today, they have to abide by, like all the things related to authorizations, disclosures, when in fact the BAA its ability actually narrow than a covered entities in that it has to be confined to whatever the terms and conditions of the contract under which they're operating, which is sort of a confinement that's not contained by covered entities. So in a sense, that their privacy obligation, is almost kind of narrower in some ways. But I would not probably typically I would not advise a client to, you need to make sure you have a privacy officer unless they are a business that offers privacy officer related services, for example. Would you agree with that or not?
Yeah. Although I think it probably depends on the type of organization I'm dealing with. if it's one that's interacting with a bunch of different covered entities and is getting a lot of protected health information, then I think it's just beneficial to have in place, even if it's not specifically required. Especially because, as we just said, they're still going to have to comply with all the use and disclosure requirements. So having someone that you can turn to ask questions, I think, is beneficial.
Yeah.
So I'm kind of, it is, to me, it's kind of surprising that they don't require a business associate to have a privacy
officer.
If they're trying to, even if I agree with you, even as we're saying they're not having to put in every single component of the privacy rule, it's still broad enough and a big enough chunk of it that why didn't they require someone to oversee all of it? Because if you're going to hold them, especially if they can be held accountable for violations, I find it. I'm just waiting for the first clear settlement or breach announcement where the business associate gets whacked, and someone steps in and says, "Well, why didn't you have someone overseeing what was going on here?"
Yeah. Well, you heard. There have obviously been significant breach associated with the business associate, and that you're familiar with the Minnesota I think it was Fairview case where a collections agency had a laptop stolen, which of course, just saying your collections, you've become a dark mark to plenty anyway.
Yep.
And not only was the laptop stolen and unencrypted, but they found out that they had the complete medical record. So one of the things they really rode them on was the covered entities violation of the minimally necessary rule.
Yep.
And in fact, that collections agency was kicked out of the state. They are no longer allowed to operate in the state of Minnesota.
Yeah, no, I remember that one. That was the one where they started getting heat from all over the place, right?
Yeah. That's an easy whipping boy, so to speak. So, yeah.
Do you mind, guys, if I actually take a couple of questions from the live audience, just to kind of jump back and forth a little bit?
Absolutely.
Really good ones. So one of our attendees sort of gets back to the continuity care question. A provider sends a referral to radiology. Radiology is to call a patient and schedule an exam. If it's a new patient for the radiology practice, can the radiology leave a message on their voicemail with the family or patient when they haven't received the radiology's NPP yet?
So in other words, at least with that practice, the patient has not authorized the appropriate forms of communication. Is that
right?
Yeah.
Right, and they're trying to schedule a call. Right.
Matt,
So I guess they can't, right?
Yeah, I would say I think you can probably leave a voicemail. Just don't leave very much information in it.
Right. Just say where you're calling from, right?
Yeah, just say where you're calling from and say, please call us back. I think this goes into that, the practical reality perspective of things is, you're not always going to catch someone when you try to call them. I guess one option might be if you don't get them the first time, don't leave a message, but try to call back another time and see if you can catch them. But then if you keep missing them, then at some point you're going to have to leave a message. And I think just say where you're calling from and say, please give us a call back, and then you're not.
That's enough. Yeah.
You're not specifically giving away the farm there.
Yeah. I think it's worth noting, though, that, and you've sort of touched on this earlier, but patients do have the right to request the time and manner of communication. So if a patient said, and you again, Matt, you're probably familiar with the case of there was a young woman who, I think this was in North Carolina, who was 18, living at home, religious family. She believed she was pregnant, went to the cell phone. They called the family, which obviously was their first strike against them, and they disclosed to the mother that their daughter was pregnant. So there's the minimally necessary kind of principle. And I do not know how that case ended up being adjudicated, but it was ugly. And so you need to have procedures in place to make sure you're properly communicating with your patients.
Yeah, that's a good point about, as you said, the patient can specify the time and place and manner that they want communication. So if, you're getting the referral, maybe you want to ask the referring provider, their office, has the patient given any specific instructions, if nothing is revealed to you, because that way you can help prevent running afoul of something and having someone, try and allege that you should have known or that you knew about a restriction.
Yeah. Do you need a signed release regarding HIV or substance abuse if the communication is internal? You've got a colleague. I'm assuming that's what Adam's talking about. So, do you need a release from provider to provider in the same organization?
There is a special category. I'll let there's in terms of requiring written authorization. There is a special. You do require written authorization for the release of psychotherapy notes, which is kind of an exception to the rule. But this is for internal, and I'm right on that exception, right, Matt?
Yeah, psychotherapy is its own coverage, and because psychotherapy is just a unique aspect altogether. Because that, as we know, that's excluded from the right of access, and just given a lot of very special protections.
Yeah, actually, the technique clarified said actually within a provider network. That could be more than just
Yeah.
Obviously.
So the difficulty in being able to is a lot. HIPAA might provide for one thing, but then you have to also look at your layer of state law, which oftentimes will provide more restrictions. Like I know, so I'm in Massachusetts. We have a specific law that deals with how HIV and AIDS information can be disclosed and shared. So I will honestly turn there as opposed to necessarily going by whatever's in HIPAA, because a general principle to keep in mind is the interplay of federal and state law is, while a federal law is the law of the land and takes precedence over state law can create restrictions within the federal law. It just can't try and run contrary and broaden what the federal law would do.
In other words, the federal law is like a floor.
Correct.
And the state law could potentially be more restrictive than federal law.
Yes, and the biggest areas I see that in with minors.
Oh, right. Yeah, of course. Yeah.
Hey, Matt, is there a registry of preemption, state preemption in HIPAA anywhere? Like, is there one place you can go to say, you wanted to find out, hey, how is my state's laws more restrictive? Is there a place you can go and find out that information, or does it not exist in that form?
That is a good question. I have this niggling in the back of my head that I've seen resources like that. So I will punt on answering that specifically, but I will say that I will take a look, and if I find something, I will post it into the new LinkedIn group.
That'd be great.
That'd be our new LinkedIn group.
Hey, LinkedIn group.
Yeah. Another question from the audience. Can you speak to blanket authorizations? Are they allowed in the notice of privacy practices? Sort of a blanket auth.
That's. There's, especially when it comes to like marketing and fundraising and sale of PHI, you need to be pretty specific about what you're going to do.
Right.
So it is very hard to try and do a blanket authorization.
Just can't say, hey, you're agreeing that we can use your information any way we want.
Right. I mean, because, I hate to say it, but, if you're going to try and sneak that into an MPP, that's going to be I think that's probably beyond the bounds of what can go into there. But it's also, I've had this discussion about, how many people have actually read the NPP when it's been provided to them.
They don't. We just sign it. Right?
Yeah. So I hate to hear that. One side of me hates to hear that. Like basically, probably 5% or less of people maybe read it. But so it's. So trying to sneak things through in there is, I think, going to be very problematic. And just even if you just do a blanket, I think you're going to run into trouble there.
Yeah. Are patients for patients that are required, basically a patient portal required password? It's got to log in, and sort of password protection. It's really just, I think, asking your opinion. Is the account number, phone number, and date of birth enough authentication? That is the patient who's logging in.
Yeah, this is a really interesting question, and it's really dealing with the question of what's under authentication access control principles of what's called identity verification. And I have a general concern that too many vendors are not doing a good enough job related to identity verification and authentication. And so the safest way to do it is in person. Generally, if a person's in your office and you've seen that, the best way to do it, honestly, is to set that up for them right there, and even the portal with them. And then if you can give them some sort of unique code to take with them, that would be great. Where I get most nervous is where a patient, let's say, is calling in, and that you may have a record for them, is what are but let's say you don't have an email on record, or they're asking you to send the authentication to a different email. I have this concern because I've actually had more than one client that ended up disclosing a chart to the wrong person. I think those procedures should be tighter than using, a single email and using information that's fairly readily available. So that, such as date of birth, address. I even would put Social Security number in that. In these days, I would put that. So if I would like to see more vendors, more clinics and hospitals tighten their authentication and identity verification procedures, especially as it relates to providing that information remotely. Having said that, as is often the case, you're gonna get more security and more cumbersome workflow, and the rules don't really say you got to do it one way or another. Just keep in mind that if you end up with an inappropriate disclosure, you could get in trouble for it. I mean, you could get in trouble for it. So, Matt, you have any other thing to add to that? It's
no. I think that was a pretty comprehensive response to it. Maybe the only, kind of from the authentication piece, it's you have to be taking some reasonable steps. So I guess it's have you reasonably done to verify that you're talking to the person you think you're talking to?
Yeah, I mean,
it's becoming a more nuanced issue.
Yeah, I mean, like giving them a one-time code that they use for the first time they log in is one way. You could send a text message if you've got a confirmed mobile phone number. You could have a method where you text, a unique code to them, like that's a form of two-factor authentication. That could be a way to do it. I'd like to see more people doing those kinds of things than just an email with a few basic facts that are fairly readily available.
I think that sounds like good advice. Just because the danger has increased so much in recent years, and the risks are so high with the ability that if you get if one bad actor is able to sneak in the door, now everything's open to them. I think the standards are probably the practical standards. What it might used to have been.
Yeah, the scenario I gave involves the unauthorized disclosure of a single record, which is, I'm not saying that's not a terrible thing or that it's not a problematic thing, because it is, but and when it comes to the patient portal world, I just have general concerns about security, like are the vendors or the covered entities, have they designed that software to with security in mind? Have they baked into it the features related to access control, authentication? And I have a concern that a lot of those tools have not been properly vetted for security, and that somebody's gonna a hacker is going to be able to hack into those databases and get information. Not aware that it's happened yet in a portal, but I think it's probably going to eventually.
Yeah.
So.
Yeah. Speaking of tools, what tool would you recommend for determining reportable versus non-reportable?
Can I answer it, Matt? Can I please?
Sure.
Please,
okay.
please.
It's like Mr. Cotter, and now I'm really dating myself, So there is no such thing as a non-reportable breach. That's the answer to the question. There is an incident and there are breaches, but all breaches have to be reported. And then now I'm going to pass it over to Matt, and I'll let him take on what is a breach.
Yeah, so you took the easy part.
Yeah, I took the easy part, of course.
Yeah, so in terms of what's a definition of a breach, the quick and glib answer right out of the definition is an unauthorized use or disclosure or access to unsecured PHI or ePHI.
Yeah.
So I think that goes back to one of the points you made earlier, Steve, about secure the PHI, and that's going to do a lot to protect you against a lot of the dangers or the bad things that can happen to you. Because a capital B breach for PHI or ePHI.
Yeah, and that was a change under Omnibus, because prior to Omnibus, so you do a risk analysis, but what I call risk analysis for purposes determining breach, and under the old standard, you do it was the risk of harm standard. So you'd have to determine, was the patient or victim likely harmed by the breach? And that went away with Omnibus, and it basically kind of pointed back to the privacy kind of obligations, and so it clearly lowered the standard, and
and I think that's a good point about the changes from the Omnibus rule. Don't forget that under Omnibus, if you have a breach, it's presumed to be a breach unless you can prove otherwise. And then it's that the low probability issue, and they allegedly created, and I always, for some reason I can never keep these terms straight, but they tried to create the one-size-fits-all standard, but then in their explanation of how to apply it said, oh no, you need to look at all the facts and circumstances when you're going through the 4 factors and elements of considering whether there's a low probability.
It was further disclosed,
So so it's the essentially they changed the wording, but it still goes back to, for the most part, kind of the standard from the interim final rule. Although again, definitely look at the changes from the Omnibus, because it is clear that it's per se a breach unless you can show otherwise. So it's, but again, you're looking at the unsecure information, which is kind of a good starting point. So if the information you're looking at was secure, taking electronic information, if it was encrypted and someone just broke through that.
Yeah, that's a really good point of clarification, because if maybe so if in the way the question was asked, if you have a breach of encrypted data, maybe that's still a breach. So that's actually, I think an important consideration.
And I think it's definitely worth highlighting the point that you made, that if it's a breach, you're reporting it no matter what. The only question is, who are you reporting it to? And that's where you need to pay attention to the 500 threshold. And
when,
God willing, you're under the 500.
Yeah. So if it's 500, you're reporting it to the Office of Civil Rights within 60 days. If it's less than 500, you're going to do it annually, and you need to have a log that you. And breaches are common. They're very common. People send wrong email to the wrong addresses. You actually have to report that annually, but I don't think, and even there's the case of the hospice in Idaho who had 400 records breached and reported under the annual reporting requirement, but still they were still required to take, fulfill a corrective action plan. So it's not like under 500 lets you off the hook, but the onesie-twosies, unless there's a pattern that
Yeah, to me the big one is when you cross the 500, then you have to go to the local media. And that's one I always use to scare people with, because that is where your reputation can get shredded.
That's not how you want your 15. You want to use up your 15 minutes of fame.
Yes.
There are better ways to use that, that. So.
Well, believe it or not, we're actually all out of time. And just for the benefit of the people who are on the phone and are listening in through their computers, I will send out a link to the recording so you can listen to it again, hopefully after the holiday, after you've enjoyed a long weekend. And, of course, we obviously didn't get to every question that was answered in the registration process or from our attendees. So please reach out. Email Steve directly and Matt directly. They will respond and they will answer your question.
Well, yeah, but we're going to do it in one place now.
Well, some on LinkedIn, but yeah.
Of course, you can always call me or email. So.
And we're very serious about. Yeah, it's both very responsive. I know that for a fact. And, of course, our HIPAA Chat on LinkedIn group is really a great place to post some of these questions. And, in fact, I may take some of the questions that we didn't get to and pose them myself on the group. Just Just, again, for the benefit of everybody. So, Steve, Matt, thank you. Again, Matt, especially thank you for being our special guest today. We appreciate it. And have a safe holiday, and we'll see you next month on HIPAA Chat.
Thank you. Bye, everybody.
Thank you.
Have a good weekend.
Bye.